afternoon, good evening, depending on where you are. Welcome to this session of WTO Public Forum 2021 on China and WTO reform towards consensus and resilience. My name is Weihuan Zhou, Associate Professor and Director of Research at Faculty of Law and Justice, University of New South Wales, Sydney. I'm also a member of the faculty's Herbert Smith Freehills China International Business and Economic Law Center. It is a great pleasure and honor to chair today's session. We have a very distinguished panel of speakers today, and they are all highly regarded in the field, so that none of them actually needs a detailed introduction. What I will do is that I will introduce each of the speakers briefly before their presentations, so that you will have more time to hear from them and to engage with them in the Q&A session. Let me start by congratulating the organizing institution of this session, the China University of Political Science and Law, CUPL, for its success in a highly competitive application process, and recognizing that this is the second time that CUPL team has won the opportunity to organize a panel at WTO Public Forum. Personally, I would like to thank Professor Kongqun Jiang, Dean of the School of International Law at CUPL, for inviting me to chair this session. Due to some technical limitation that we can only have 5 speakers in the Zoom at the same time, Professor Kong has kindly agreed to remain in the audience with us. But Professor Kong has asked me to deliver some opening remarks on his behalf, and I will do so now. On behalf of the CUPL team, Professor Kong is grateful for the opportunity to organize the session at the WTO Public Forum again. I would like to thank all the distinguished speakers who are from 5 universities in 3 continents. I believe that today's presentations and discussions will showcase how consensus on WTO reform can be forged despite differences. International cooperation and consensus is much needed today to build up a resilient multilateral trading system. I would also like to thank all participants around the world, as your presence not only signifies your support of the public forum, but also for the WTO. Personally, I would like to thank the CUPL team, led by Professor Kong and Associate Professor Ding Ru, for organizing such an important and timely session. Very briefly on today's agenda, we have 4 speakers, and each will speak for about 8 minutes to set the ground for discussions. And this will be followed by roughly 20 minutes Q&A. Without further ado, I'm pleased to introduce our first speaker, Professor Zhang Yuejiao, who should be widely known in this audience, given her former role as a member and chair of the panel body. Professor Zhang is currently Dean of Institutes for International Dispute Settlement at Tsinghua University. She's also arbitrator at a number of institutions or arbitration centers, including International Center for Settlement of Investment Disputes, as designated by the President of the World Bank. Professor Zhang will talk to us the challenges for WTO's dispute settlement system and reform proposal. Professor Zhang, the floor is yours.
Hi, thank you, Professor Zhou, and thank you everyone, the outstanding panel with so many audience. And also I would like to join you to thank Professor Kong, the Dean of Law School, and also Professor Ding Ru. They have done tremendous work in order to make this happen. And also I see so many good speakers, so I'm afraid that to be the first one. I would like to take this opportunity to share my personal views on the dispute settlement achievement of the WTO, including challenges and the ongoing reform proposals. It's totally my personal views. So I will cover first the challenges Please, next slide, maybe 2. So could you move another one? Move. Next slide. You see that I will cover these issues. First, I will touch upon the challenges faced by WTO. As you know, the WTO is a member-driven international organization, one member, one vote. So the democratic arrangement, that consensus of 164 members, the decision-making process very often very slow. That's the first problem. And the second one is the current lack of financial resources, maybe the previous one. And the gap between developed members and developing members is widening, and international law fragmented, which which affect the efficiency of the dispute settlement of the WTO, and the rapid development of technology, such as digital economy and e-commerce and others. Point 6 is government's rights to regulate, to protect the public interest, and also to maintain the stability of the society. Second is food security, subsidies to the poor regions. And point 8 is, I think currently they should have an objective assessment of the WTO and the dispute settlement, particularly the appellate body. Point 9 is they need more political will to pursue for the reforms. And I think the first urgent task is to resume the appellate body. I will come to this point later. And point 10 is member-driven, the relationship between a member-driven institution and independent and impartial dispute settlement. Now, I would like to share my personal views regarding the dispute settlement system of the WTO. Overall, it's very successful, and it's also called by people the crown jewel of the WTO. Two-tier approach, the panel, ad hoc, and a permanent appellate body is a balance between the two tiers. And panel establishment and adoption of reports from consensus into negative consensus, it becomes automatic and very fast. So from get time, power-oriented into quasi-judicial and law-oriented of WTO. If we look at currently other international organizations, such as UNCITRAL, they are working on the appeal system for investment dispute. Working Group 3 reports indicates that ISDS case, when a government is involved, an appeal system of correction of errors is desirable and feasible. And when we look at the regional FTAs and the bilateral BITs, some already introduced an appeal system. And a dispute involved a state, since a public law and international treaty involved, is different than a commercial arbitration based on private law. An ad hoc panelists of the dispute settlement, they are not full-time professionals. So sometimes they have different interpretation of law. So an appeal system to correct is necessary. Next slide, please. Next. And dispute settlement, if we look at the current situation, it's quite successful. I will show you a table that by December 31st, 2020, the WTO has already handled more than 600 cases. And compared to the GATT for 50 years, only 300, almost double. So it's quite efficient. And compared to other dispute settlement institutions, such as International Court of Justice, for the first 50 years, there are only 61 judgment and plus 23 advisory opinions. And for the exit, currently I'm working for, that now they have their cases rapidly increase up to 600 disputes. But the average close of time is longer than the WTO. If we look at the wide participation of the WTO members to participate in the WTO dispute settlement, among 164 members, there are about 110 participate in the WTO dispute settlement. On appeal, 81 of the WTO members have participated. It means that shows their trust and the confidence on the WTO dispute settlement. So that's why the WTO dispute settlement is the most successful function among 4 functions of the WTO. But however, the current appeal process facing political crisis, you all know that the blockage of the appellate body member selection by 1 member since 2017 and no replacement. By 2019, December 11, only 1 appellate body member left, and the appellate body stopped functioning, returned back to GATT 70 years ago by consensus, slow and long process. The DSU does not change. So it means all members, they do have the right to appeal, but no appellate body to handle their appeal requests. Currently, there are already more than 10 appeal cases submitted to the DSB, but unfortunately still pending, prolong the timing of dispute settlement. And next, there are also other issues such as Article 11 cases. More Article 11 cases, it means that they will bring new facts to the appellate body. So how to define whether an objective assessment is a legal or factual issue? And currently there is no remand authority. So they do from time to time completion of analysis. And they need to address all issues appealed. So those issues for the DSU reforms, numerous numbers of proposals for improvements already made on the table. First, enhance the transparency. And secondly, the strengthening the professionalization of a panel process and enhance third-party rights. Then to partial adoption of the panel and appellate body reports, the protection of business confidential information, special and differential treatment to the least developed countries, particularly to reduce the litigation costs. Then reforms, I think several reforms already going on that I believe that dispute settlement is a public goods, should be prompt, positive, convenient, and low cost. Now it's electronic filings, particularly under the pandemic. So we use more often online dispute settlement, including virtual hearings and deliberations. And the AB has also made several improvements, a stricter code of conduct, and unpredictable random system. So, and shortening the reports, putting page limits. So all those are positive. There are several systemic issues. For instance, increasing human resources, cooling off of 3 years, no expert communication, and how to supervise, and the fees payable, and to avoid the abusement of the dispute settlement, and avoid forum shopping is also a problem. Improve investment disputes. So, and others, I think they are talking about. On the potential reforms, I would like to raise the following points. First, documents issued by the panel and the appellate body should be rather friendly, concise, correct, and shorter. And certain provisions of covered agreements require modifications or legal interpretation by the ministerial conference. They are the legal authority. And point 3, the 90 days time limit for appeal proceedings should be reconsidered. But I think it's more technical issue. For instance, change the working days or extension letter agreed by the parties to be approved by the DSB. And for the internal legislation and internal law, we always consider it as a fact. So we can issue this through the DSB to reconfirm the consideration of the dispute settlement mechanism. And the appellate body should observe its mandate, and the DSU should follow the covered agreements. A case is binding on the parties, has no precedential effect on the following cases. At point 6, a person who ceases to be a member of the appellate body should be able to complete a current appeal if approved by the DSB. And point 7, the term of office currently is 4 years, 2 terms. But if some members or all members agree with 1 term of 6 years, it's feasible to me. And point 8, the WTO dispute settlement mechanism should have the right to issue urgent and provisional measures. Point 9, expert judges and lawyers should be broadly representative of the WTO membership. And finally, a strict code of conduct should be observed by all personnel involved in the dispute settlement. A few words on the MPIA. MPIA is a temporary solution of appeal function. MPIA is open, inclusive, and volunteer, but with some shortcomings. For instance, legal status and a limited number of MPIA. Still more than 100 WTO members, they do not join MPIA. And for their rights to appeal, how to ensure? Thirdly, lack of financial support and lack of logistic support to the MPIA. So there is no secretary support, no legal staff, and enforcement of reports of the MPIA is not quite clear. Therefore, my view is MPIA cannot replace a permanent appellate body. So early resumption of appellate body is very much needed. And concluding remarks, the WTO dispute settlement is very important. The central to the rule-based international trading system, and also the most successful element of the multilateral trading system since the establishment of the WTO. Any reforms of the WTO and its dispute settlement mechanism should observe the principles of the WTO to preserve the integrity of the dispute settlement mechanism designed from the beginning and already embedded in the DSU. Specifically, the reform should do no harm to the fundamentals of the WTO and its well-established dispute settlement mechanism. With the ongoing internal reforms and a further improvement of the appellate body, as well as to the dispute settlement mechanism, I believe that the dispute settlement mechanism will better serve WTO members in the peaceful solution of their disputes. And the urgency is to restore the appellate body function, and it cannot wait for other negotiations of the WTO. The appellate body is the first priority. Any unilateral approach would be harmful to the WTO and this dispute settlement mechanism. Instead, multilateral efforts will bring all members on board for WTO reforms. A modern and efficient dispute settlement mechanism will contribute an even better function to the robust institution of the WTO. Thank you very much.
Thanks, Madam Zhang, for a very insightful, personal, and also systemic review of the dispute settlement mechanism, and that provides us a lot of food for thought. And I'm sure we're going to come back to some of the points in the Q&A. Our next speaker is Professor Brian Mercurio, Simon Lee Professor of Law at Chinese University of Hong Kong. Brian is a leading and well-known expert on WTO law, free trade agreements, IP-related issues, and international investment law. Many of his work have also focused on China. China's role in international economic legal order and WTO reform has been at the center of academic and policy debates. How best to understand China's position on WTO reform, including challenges and opportunities for consensus building in the ongoing negotiations, remains an open question. Some of the major issues will be discussed in Brian's presentation today. Brian, the floor is yours.
Thank you very much, Professor Zhou. It's an honor to be with you and to follow Professor Zhang as well. This panel is obviously on China and WTO reform, and oftentimes, I think I have to state at the outset, oftentimes we hear, the WTO is in crisis, it can't reform, and we see how the WTO bounces from crisis to crisis. I mean, this audience is sophisticated, and it will understand the truth of the matter is that it's members, governments, that are really creating crisis or standing in the way of progress. I'm a real backer of the multilateral trading system, and I favor a strong and respected WTO. But I also believe that reform must occur in order for the organization to maintain legitimacy and really for the global economy. China, as undisputedly, is a leading trading nation and undoubtedly has a large role to play in any reform agenda. China's benefited from the stability, the market access opportunities, the rules of the WTO. The WTO norms, backed by the strong dispute settlement system, which we just heard about, have allowed China's exports to flourish over the past 20 years and allowed China really to meet its expectations of WTO membership, export growth, export-oriented development model, poverty reduction, economic growth, etc. The breakdown of the multilateral trading system and increasing trade conflicts is not in China's interest. When the trade friction with the US increased in 2017, it appeared to me that China was a bit worried about what the future would hold. China proved to be quite resilient throughout the trade war with the US and emerged in a very strong position, perhaps stronger and more confident than even prior to the trade war. It's thus clear to me that China will not simply accept demands of others in order to restore order at the WTO. And I really don't think that some people, commentators, even governments, appreciate the fact that China really is operating from a position of strength now, not of weakness. I mean, in simple terms, that it's not going to allow itself to be bullied into agreeing with any proposal that's on the table. Unfortunately, really everything I hear coming out of think tanks and from academics and commentators in Washington, in Brussels, beyond, is how the system must change really to constrain China, or how China must change its own practices and systems. Many of these issues, of course, are long-standing. They date back really to China's accession, whether you want to say state-led development or IP, exchange rates, transparency. But the missing element here, and what I never really hear, is why China would accept any of the proposed changes, or what could be traded off in order to get China to agree to an exchange. You know, what is China looking for in WTO reform, and why would it actually agree to change some certain fundamental elements? So negotiations really obviously can only succeed if there's a give and take, concessions, compromise. The reality is, my own personal view, right? China, along with the US and EU, are the leading members of the WTO, perhaps closely followed by Japan, India, Brazil. These are the countries which must come together for the good of the system. We know really China can and must play a constructive role in any reform. It's going to be a key player in most issues, but certainly subsidies, state-owned enterprises, agriculture, intellectual property, technology transfer, services, digital trade, emerging green issues. It's time to really understand China's position and to think clearly of possible areas of convergence. I think the time to say China must do this, we must change the WTO this way, is very one-sided, right? The model must be of course, negotiation, convergence. Here, again, my own opinion, negotiating in silos, each individual issue separately, which is the trend, will not work. Agreement, I think, will require trade-offs across issues, and this is not going to be easy. No doubt, China wants a WTO-centered regime, but China remains resilient even in this time of uncertainty. Its economy is strong. It's not simply going to capitulate just to get the WTO back on track. China's regional networks are growing, and of course, it recently applied for membership to the CPTPP, perhaps maybe sparking the Biden administration to get or elucidate on its trade policy in the process. In the meantime, uncertainty for traders and governments will remain. I think middle powers in particular are going to be caught, I mean, no pun intended, they're going to be caught in the middle. But I will say that such countries, these middle powers, actually also have an opportunity. And they have an opportunity to maybe usurp some leadership and attempt to direct the future of trade in a way that maybe they wouldn't be able to do under normal conditions. And here I'll just use one simple example, the DIPA, the Digital Trade Agreement by Singapore, Chile, and New Zealand. It's an attempt by really smaller, even maybe not so much middle, but smaller powers to try to shape an agenda for the future. So, I mean, I think China's post-WTO development may not have been entirely foreseen or may not have met the initial expectations of the US and EU. I think that's clear. But really, we can't dwell on the past now. We actually must look forward and come together to advance the multilateral trade agenda in a mutually beneficial way. We know China will have a role. It will have quite a large role. Actually, we know what others want from China. And my question, which I leave you with, is do those other countries know what China wants in return? And when are they going to ask the question, and when are they going to engage in real dialogue? So with that, I close. Thank you for listening. And again, pleasure to be a part of the WTO Forum today.
Sorry,
I turn it back over to you.
Yeah, I was muted. Thanks, Brian. That's very concise and powerful, and it's really thought-provoking. I think most of the issues I've identified and leave to the audience and us to think about. Our next speaker is Professor Volker Robin. Professor Robin will touch upon one of the perhaps hottest topics of today in relation to the EU's carbon border adjustment tax mechanism, which is also known as CBAM. Professor Robin is professor of energy law, international law, and global regulation at the University of Dundee. Among his many impressive contributions in the general field of international law and his specific field on energy law, Professor Robin advised the Energy Charter, the European Parliament, international organizations, and national parliaments. He also serves on the board of the Max Planck Encyclopedia of Comparative Constitutional Law. And Professor Robin will take us through the key features and recent developments of CBAM, and the issues it may create under WTO, and reaction from China. Professor Robin, the floor is yours. I understand that you're going to share the screen from your side, so maybe I'll just stop sharing screen from my end.
Yes, thank you very much. It's a great honor to be here on this day and with these distinguished speakers. Special thanks, of course, to Dean Kung for inviting me to this event. Let me share my slides now with you. I hope you can see them now. Okay, so I'll be speaking from this set of slides now, and start from the beginning. And it's as was introduced, a talk that will be specifically focused on the EU carbon border adjustment mechanism, which the European Commission has now proposed and launched into the legislative process. That's particularly interesting, I think, because it is a clear illustration of the issues faced by the WTO and countries such as China, as in particular we negotiate the rise of new values, such as the protection of the climate, and how it fits with the trade agenda, really, that the WTO so powerfully pushes. So that's really the big picture, so to speak. How do we reconcile some of these conflicting values? And also the other important point is the contradiction between, or the conflict, if you may say so, between multilateral approaches and unilateral ones to solving this, or to addressing this conflict. And I'll come to this. So all of this comes directly to the fore in the discussion of the CBAM. So that's originally a French idea. It's been around for a long time, and was then proposed directly in the European climate law. I think that's a very important background to this, where the European Union has committed to achieving climate neutrality by 2050, and that is in line with Article 2 of the Paris Agreement, which says effectively that the world should limit the increase in global temperature to well below 2 degrees Celsius. Then there is the European Parliament that pushed for a carbon border adjustment mechanism already for 2023. And now the European Commission has published a proposal for such a regulation. Now you need to know that you do know that the European Commission is kind of the executive of the European Union. It cannot make law by itself, but it has the monopoly of proposing legislation. And that's what it has done in this particular instance in July of this year. And that has kickstarted the legislative process itself, which will involve the Council, effectively the group of all the 27 member state governments, and the European Parliament, which represents the European citizens. So we may see an end of this legislative process with the CBAM being adopted by 2022. Now, the important background to this is really the European approach to addressing the climate objective. And you need to know this, that is really that's really the main instrument the European Union has, is to bring down the amount of carbon dioxide that is emitted into the atmosphere. And that is by the European Emissions Trading System, ETS, which is attempting to put a price on the use of carbon by European industry. So very briefly here are the elements of it. First, it is a cap. The ETS introduces a cap on the total amount of emissions. That's declining. That cap is declining, so ever fewer emissions will be allowed over the future. And it is now effectively has been strengthened again with a view to a reduction of 55% to achieve that carbon neutrality objective. So that's really the background to this. And the other element is that the emissions, that cap is broken down into allowances for individual covered stations. So that's the operators that emit the carbon in their production in Europe. And then these allowances are freely tradable to create an incentive for the operators to deploy their ingenuity really to find cost-effective solutions to carbon reductions. And that system now includes more than 11,000 stationary sources, oil refineries, power stations, paper, cement, and so forth. All the big emitters of carbon effectively are covered. And as I said, need to have the relevant allowances in order to be continuing to produce. Now, very important to this picture is that there are parts of European industry that are not covered, or they are covered, but they receive the allowances for free for the time being. So generally, if you are a covered stationary source, you need to acquire an allowance. These are auctioned off on a daily basis and you need to pay for them. That's the whole point, making it more expensive to use carbon intensive industry processes. But to a certain part of the industry, these allowances continue to be given for free. And these sectors are considered to be in danger of so-called carbon leakage, meaning, in other words, to move to other jurisdictions that don't have such stringent systems in place. And it is precisely meant to address this particular problem that the European Union introduced the CBAM. But before I get to this, I just wanted to show this slide to you, and this shows the price of the allowances over time. That price has been going up quite dramatically, more than 60 euros per ton carbon to equivalent in most recent times. Of course, that's exactly intended. The intention has always been to drive up the price of these allowances, precisely to create a strong incentive to reduce the carbon emissions in the first place. But it is an important background to this. So what does the CBAM the Carbon Border Adjustment Mechanism, try to do? It has really several objectives, and I'll come back to this in the analysis on the WTO law. So first, the primary objective is the climate action. It's effectively, the idea is to prevent carbon leakage, industry going effectively abroad and emitting in other jurisdictions. And at the same time, effectively, it is a way of introducing, the objective is to get rid of the free allowances and also charge these industries when they emit in Europe. So climate action is the first objective. Also importantly, I think it's fair to say that the objective is to incentivize other jurisdictions to introduce, if not the same, then a very similar system of emissions control. And I come back to this because this does raise issues under WTO. A third objective is to create a level playing field, effectively for operators in Europe and outside of it, under environmental rules, so to speak, preventing carbon leakage. I mentioned that. And the final point is really revenue raising. I think that's another issue that needs to be considered under WTO law, because it is meant to raise revenues for the European budget. So the principles that lie behind this, according to the European Commission's proposal, is that the CBAM should be based on the following idea. It should be really closely mirror the price being charged to EU producers for emitting carbon, to ensure the fairness of the system and prevent discrimination.
Professor Robin, sorry to interrupt you.
Yes.
But we have 2 minutes left.
Okay, and it should also avoid importers paying twice for their carbon content. Phased in implementation. There were a couple of, I'll speed up a bit here because I still want to get to the WTO side. There are a couple of design options. So the idea is that the importers will have to acquire a separate set of allowances equivalent to the ETS, but not the same. That will be charged on the basis of a benchmark for the relevant product, so the good that is imported, what is effectively the embedded carbon. And these allowances will not be capped, they can effectively not be traded, and the price will be determined weekly. So now what is the issue about WTO? There are a couple of disciplines that may be infringed by this unilateral action, particularly in Article 3.4 is probably implicated. But the main important issue is, do the exceptions apply and cover this particular instrument? There are two that can be considered. One is 20B. Does that under US gasoline, is there a jurisdictional limitation because it does try to protect the climate? That's an issue. Is it also a matter for protecting human health? I can't go into any details of this. Probably more relevant is 20G. There is a number of issues about whether climate is an exhaustible natural resource, whether there's a close and real relationship between the CBAM and that objective, and whether it's even-handed. We know that under the made effective in conjunction with. In the interest of time, I really want to focus on the chapeau, which is really the critical test under US shrimps. And there must be not discrimination. I think that's the key issue, not discrimination of the importer. And China obviously will be particularly heavily impacted because many of these industries that will have to pay are exporting from China. Now, the key issues, this measure raises a number of issues that haven't been addressed, I think, so far by the appellate body jurisprudence in full extent. Because one of the key issues is that the system is designed to effectively have the same price posed on products by the exporting country. So what happens if a country such as China, for instance, has introduced an emissions trading system, which it has, but the price is not the same that is actually charged of the embedded content, the embedded carbon content? That is one of the big issues.
Professor Robin,
yes.
Sorry, my apologies. I have to ask you to conclude because of the time. I'll
conclude this. And the other big issue is, of course, does the is the multilateral system of the Paris Agreement compatible with this? Because, as you know, there the idea is effectively nationally determined contribution. Each country makes its own ambition, and that's another question. Okay, I think I conclude at this point, and I can go into any of these issues in more depth in the Q&A. Thank you.
Thanks, Professor Robin. That's a very, very comprehensive review and raises lots of interesting issues. It's just a little bit unfortunate we are actually running out of time. So, I mean, you mentioned discrimination. I think that's a very good pathway to our final, but by no means the least speaker, Mr. Li Xie. Mr. Li is the Deputy Director of the Trade Remedy and Investigation Bureau of the Ministry of Commerce of China. He used to work in the business office of the Chinese mission to the European Union and wrote the responses of mechanical and electrical companies to EU technical barriers. He's also the co-author of US 337 investigation, rules, practices, and cases and guidelines for responses to foreign trade remedy investigations. Mr. Li will explain to us the importance of upholding the principle of non-discrimination in WTO reform and why it is key to defending and improving the multilateral trading system. Mr. Li, the floor is yours.
Okay, thank you, Professor Zhou. It's my pleasure to attend this forum. Every guest's remark and proposal to air today are very impressive and inspired. I'd like to share my personal opinions on the non-discrimination principle in WTO reforms. Reviewing the historical evolution of the rules-based multilateral trading system, non-discrimination has always been a foundational principles and the consensus of all members. These principles has contributed significantly to the development and prosperity of the global trade and world economy over the past 70 years. Nowadays, it's also indispensable in WTO reforms. I'd like to share 3 points on non-discrimination. First, the non-discrimination has been the cornerstone of the multilateral trading system. Non-discrimination is a common goal shared by every person and every nation. Members recognize that in order to eliminate discriminatory trade and investment barriers, the concept of openness, inclusiveness, equality, and reciprocity are essential, and these were written into the WTO trade agreements. This established non-discrimination as one of the foundational principles of the WTO. The principle of non-discrimination is broadly reflected in the preface of the Marrakesh Agreement and articles relating to most favored nation treatment and national treatment in GATT 1994, and several individual agreements, such as GATT and TRIPS. These articles make non-discrimination a basic obligation of each member. The principle of non-discrimination is necessary for the protection of the interest of all members, and especially the interest of developing members. The non-discrimination principle doesn't mean absolute equalitarianism compared with developed members. Developing members are generally at a disadvantage in international trade. Through the WTO's special and differential treatment, the interests of developing members are further guaranteed. Second, practice that deviated from the principle of non-discrimination are causing uncertainty and risk to world trade. The WTO allows members to take appropriate trade management and restrictive measures to safeguard their legitimate rights and interests. But these measures should be consistent with relevant WTO rules and the non-discrimination principle. However, we are concerned that some members' trade restriction measures have repeatedly deviated from this principle. In just the past 5 years, there have been 41 dispute settlement cases alleging violation of GATT Article 1 MFN treatment and 8 cases alleging violation of Article 3, national treatment. For example, certain members have abused the national security exception of the agreement by selectively imposing discriminatory trade restriction on some members without sufficient justification. Certain members also have paralyzed the appellate body by obstructing the process of selecting and appointing its members. As a result, the discriminatory practices by members which violate the agreement cannot be effectively adjudicated and remedied. Moreover, some rule proposals from certain members set clearly discriminatory standards for different types of enterprises and different economic systems. If these practices and tendencies are allowed to spread wantonly rather than corrected promptly, the WTO multilateral trading system, built by all members through long negotiations and hard efforts, will be severely undermined and ultimately collapse. The international economic and trade order will encounter great uncertainty. Third, the principle of non-discrimination should be persistently defended and implemented by all members. At present, the world economy is undergoing profound adjustments. Economic globalization has been severely impacted by the COVID-19 pandemic. In order to improve the resilience of the WTO, the principle of non-discrimination, which is a consensus of all members and the cornerstone of the multilateral trading system, should be firmly supported and more vigorously protected than in any other historical period. China, being an active participant, staunch defender, and important contributor of the multilateral trading system, supports the necessary WTO reforms and calls for adherence to core principles, including non-discrimination. In May 2019, China submitted China's proposal on WTO reforms. Therefore, I'd like to make 4 suggestions. First, in order to make the WTO better serve the development and prosperity of world trade, we should vigorously uphold the principle of non-discrimination in the course of the WTO reforms. And we should firmly oppose behaviors and initiatives that depart from this principle. We should also respect the different stages of development and economic models of each member to enhance rather than weaken the inclusiveness of the multilateral trading system. Second, DSV is very important. In order to restrain and correct discriminatory practice effectively, we should restore the WTO appellate body and dispute settlement mechanism as soon as possible. Third, in order to curb the potential for discriminatory practices, we should further clarify the WTO rules and eliminate gray areas and gaps. Fourth, in order to timely review and correct practices that deviate from the non-discrimination principle, we should fulfill and further improve the function of the WTO supervision and trade policy review system. This concludes my presentation. Thank you for your attention.
Thank you so much for Mr. Lee's presentation on the important principle of non-discrimination. It's very unfortunate that we have very limited time. I actually received many good questions, but maybe I can only ask at most 2 questions. So maybe I'll just start with the question on unilateral measures. I mean, I raised this question for all speakers, and I would ask you to limit your answers to 1 or 2 minutes maximum. So the question is it possible for the WTO, after reformed, to prevent trade wars that launched by the US against China And I guess that question really goes into how the WTO could actually function to prevent unilateral measures. Professor Zhang, maybe I'll just invite you to answer that question first.
Okay, quickly. I think that's already answered there because the WTO has already handled several cases regarding this 301 issue. And the result is they consider and adopted by the DSP 301 is inconsistent with Article 23 of DSU. Therefore, the US should bring its measure to be consistent with the WTO. But the question is, in the reality, if one member does not perform their obligations, that's the pity and also disaster of the current AB collapse, because with the appellate body, they can continue to complete the case. And now, for instance, currently the panel issued already a decision that the 301 is inconsistent with the WTO. And then the US has appealed to the DSP. Even the DSP has already closed down for time being. So I think that still members should work together to solve this issue as soon as possible. Not only for one member, but for all members, they are going to face the similar situation, how to, to work out, to keep the consistency, keep the unconditional MFN, the cornerstone of the WTO. Thank you.
Thanks, Professor Zhang, and I totally agree with you that collective action and cooperation is an answer to unilateral measures and discrimination. Mr. Lee, can I also have your opinion on that question?
We think if the WTO reforms persistent the non-discrimination principle, the outcome will help the China and the US to deal with their dispute bilaterally or in other area. That's the basic. Thank you.
Thank you, Mr. Lee. Now, the second question I would like to ask Brian and Professor Robin, which is about the trilateral joint statement by the US, EU, and Japan on industry subsidies. So from your perspective, what kind of points do you think that China may actually agree with the reform of the ASEM agreement? Brian.
Sure. I'm going to take the privilege just to make one comment on the last question as well. And it is, if a member doesn't want to comply, I don't think that any kind of provisional measure or even adding some sort of suspension of privileges clause would actually work. I mean, as the late great John Jackson said, there's no army with blue helmets that's going to go in. And I'm not sure there's any rule if a country is hell bent on breaking the rules and hasn't adhered to an appellate body report. I'm not sure that we can get to that stage. Unfortunately, I'm also very cynical that we could even agree to potential provisional measures to be used. The DSU reform in the early 2000s, late 90s didn't really go anywhere, and there were proposals to that effect back then. I'm very quickly because I don't want to take much time, very quickly to the statement that you made. I'm not going to speak for China to say what I think that they felt, but what I will say is, I think in this issue, it's one that I very quickly highlighted that I think the silo approach doesn't work. On what basis would not only China, but other countries really actually agree to potential reforms? What are they getting out of it? I think this is where we need some cross-issue discussions to allow trade-offs to take place. I certainly don't think China is opposed discussing reforms of the SCM agreement, but there needs to be some sort of concessions that can be made by all parties.
Professor Robin, do you have anything to say about the trilateral joint statement?
No, I think this has been very, very good. I think the interesting point is to think about the targeted subsidies for instance, environmental purposes. Thank you.
Thank you so much. Now, I don't really have much time, and I've been given 2 minutes extension maximum, so I have to close in 2 minutes. Now, instead of kind of asking you guys to answer a further question, maybe I'll just ask you to give us a 30 seconds concluding remark from each of you about what do you think, either China's position or others' position in relation to WTO reform. Professor Zhang, can I please start with you?
For the WTO reform, as I mentioned, political will, very important. Cooperation, all members should be on board to pursue the reform. That's all. Thank you.
Thanks, Professor Zhang. I will just follow the order of the presentation. So, Brian.
Likewise, I think there's scope for consensus on a number of issues, and in fact, what Volker just raised, the green issues, as I referred to them. I think this is something that's in China's interest as well as other countries. It's finding that political will and the space to operate. But we need leadership, and I think Doha suffered from a bit of a lack of leadership in the governmental as well as business community. And so if we do have that drive, then I think hopefully something can be done.
Thanks, Professor Robin.
Yeah, I think the key issue is aligning the multilateralism of the trade regime with other multilateral regimes that are particularly important, including the climate, but not just that. And I think the issue that China wants to be carbon neutral by 2060 will require closer alignment between these two systems that are currently not aligned. Thank you.
Thank you so much. Mr. Lee, your final concluding remark, please.
Okay, thank you. I think the interest of the developing members cannot be neglected. China's position will support the WTO to make some reforms to defend and to guarantee the interest of the developing members. Thank you.
Thank you so much. So let me just take the opportunity to thank our organizing institution, CUPL, and Professor Kong and his team for organizing such a timely session, and also for our speakers for excellent discussion and presentation of today. And also thank you participants for your participating and your questions. I'm sure that even if today we have limited time to answer your questions, but the discussions on WTO reform will continue. Thank you all, and I'll see you.
Thank you. Thank you.
Thank you.
Thank you. Thank you.
Thank
Good
you.
to see you. It's a good panel. Okay, thank you.